defendant's great in the courtroom, you know.
Thank you. All right. Here on sentencing on Justin Johnson, who was previously found guilty on 3 counts: conspiracy to commit first-degree murder, and convicted felon in possession of a firearm. He's previously been sentenced to life on the murder, and we're here today to set sentence on the other 2 counts, the conspiracy and the convicted felon in possession of a firearm. Will there be any witnesses found?
No witnesses, Your Honor. The only proof we're going to present is a victim impact statement that we're just going to read into the record. The family would prefer it that way.
Any witnesses?
No witnesses, and I had an opportunity to review the victim impact witness.
Does your client wish to make a statement? Wish to outcome at all?
No, Your Honor.
You want to read that statement into the record?
Yes.
Take that into consideration.
November 17, 2021 is a day that will forever impact my life. On that day, it felt as if our whole world stopped. The pain of that moment was felt not only by myself and my family, but also the city and the fans around the world. In just a few seconds, a crucial part of my life was ripped away, leaving a void that will never truly be filled. Our family's holiday plans turned from gatherings of joy to grief, anger, and sadness. There will be no more moments of hearing his voice, no hugs, no family trips, no celebrations, and no laughter shared together. Those plans now exist only as memories. An unexpected death like this cuts differently, leaving behind a unique pain many can't imagine, especially when it happens so suddenly and violently. One day we're talking on the phone, sharing the newest addition to the family, and the next he's brutally taken from us while on his way to give back to the community. A horrific loss that has haunted my family every day for the past 3 years. We went from not knowing if 2 of our family members were safe to learning that my brother witnessed a tragedy that no one should have to endure. The anger, anxiety, and grief we feel aren't isolated to me alone. They're felt by our entire family. Explaining to my nephew that his father wouldn't be coming home was unimaginable. But in that moment, I saw strength in him. A strength that could only come from God and the spirit of his family, my brother Dolph. In a world full of envy, jealousy, and arrogance, many fail to realize the impact of their actions until it's too late. Yet Adolph Robert Thornton Jr., better known as Young Dolph, understood the value of giving back. He created a legacy that will endure long after this tragedy. Unlike those who committed this cowardly act, Dolph lifted up his community. He extended his hand to those who needed it most and encouraged those around him to rise higher. Our family will never be the same, but we are committed to honoring his memory and vision, ensuring that the legacy of Adolph Robert Thornton Jr. remains as powerful as ever. I think about him every day, the greatness he achieved not just for himself, but for so many others. Death like this isn't something you forget. You learn to live with it, as healing is a continuous journey. And to the one responsible for taking him from us, know this. You may deny your actions, but the evidence speaks clearly. You've shown yourself to be driven by jealousy and cowardice. You may have tried to take a man down for the sake of envy, but in the end, you've lost far more than you could ever gain. The world sees you now for what you are, and as justice has spoken, you and all of those connected to this incident will forever be known as the man who chose envy and jealousy over humanity.
Thank you. Argument?
The state, Your Honor, has filed 2 motions in advance of sentencing. The first notice of enhancing factors that the state believes and would argue to the court applies in this case. So I'll start with those enhancing factors. The state has referenced enhancement factor number 1, that the defendant has a previous history of criminal convictions or criminal behavior, in addition to those necessary to establish his range. As the pre-sentence report evidences, Mr. Johnson is a range 2 offender for both the Class A felony, conspiracy to commit murder, and the Class B felony, convicted felon possession of a handgun. Mr. Johnson has 3 prior convictions. He needs only 2, but he has 3 prior Class C felony convictions for aggravated assault. He also has a federal firearms conviction, and we could argue whether or not that qualifies as a B felony or an E felony, but there is no need since he has the 3 prior C's. He's more than enough to be a range 2 offender, the federal firearm conviction being a 4th conviction. He also has a misdemeanor conviction as well, so he has more than enough convictions to establish himself as a range 2 offender, and notably 3 aggravated assault convictions, convictions of violence, a conviction that involves the possession of a handgun. We'd ask Your Honor to place great weight on that factor in this case. We have referenced enhancement factor number 2, that he was a leader. The case law is clear on this point that the enhancement factor is not the leader, but rather a leader in the commission of the offense. We heard that Mr. Johnson picked up Mr. Smith, provided the guns, had gloves on, drove the car to the crime, and was a primary mover of what resulted in Dolph's death that day. We'd ask Your Honor to find that enhancement factor applies to Mr. Johnson. Of course, this offense has other leaders as well. We heard the testimony that this was in fact a hit from an individual referred to in trial as Big Jug, and it was facilitated by Mr. Govan, but we'd also ask you to also find that Mr. Johnson was a leader in the offense. Enhancement factor number 10, the defendant had no hesitation about committing a crime when the risk to human life is high. The state is well aware that this does not apply to the death of the victim, as that is included as an element of the offense, but rather to other potential victims. This crime happened in the middle of the day at a cookie store in which Your Honor saw the video and could see that there were workers present in the cookie store. We saw the interior video shot from behind that worker who, if she hadn't have hurriedly ran into the back, would have been right there in the line of fire. Your Honor saw bullet holes inside the business. Of course, the windows destroyed by the numerous bullets that were fired, but you also saw bullet holes inside the business on the wall, and that created a risk of death to all the workers that were there. Dolph's brother, Mr. Thornton, was also there. You saw him on the video, some maybe 10 or 12 feet from Dolph when he was violently shot, and so risk of death was created to him as well. An open business in the middle of the day in Memphis with people there, we'd ask Your Honor to place great weight on that enhancement factor. Those would be the enhancement factors that the state is asking Your Honor to find with regard to setting the sentence of these 2 crimes that we're here to sentence Mr. Johnson on.
What about number 13?
The pre-sentence report does not reflect, Mr. Johnson was on supervised release at the time. The pre-sentence report doesn't reflect that, so I don't feel that we can argue that to Your Honor. Your Honor heard testimony in the trial that he was on this release. You heard that his brother was helping him facilitate phone calls with his probation officer to try to make it look like he was still in Memphis at the time. But
that last conviction took place within that 5-year time frame.
It did, Your Honor. So I mean, the fact of the matter is, Mr. Johnson was on supervised release at the time of committing the crime. I think you have some proof before Your Honor. If Your Honor wishes to find that factor. So we did notice it. We didn't get a copy of the pre-sentence report until this morning, so I had expected the pre-sentence report to more accurately reflect that.
Okay.
Mr. Johnson, for the conspiracy to commit first-degree murder, faces a sentence between 25 and 40 years, and for the handgun charge between 12 and 20 years. In setting those sentences, a recommendation of the state, given the existence of primarily the history of convictions, including violent convictions beyond that necessary, and the risk of life to individuals other than the victim in the case, the state would ask you to set maximum sentences on those two offenses at 40 and 20 years, respectively. The state has also filed, as Your Honor is aware, a motion for consecutive sentencing. And the state has noticed two of the consecutive sentencing factors with regard to consecutive sentencing. The first, that he has an extensive criminal history. And the second, that he's a dangerous offender. And of course, the Wilkerson factors that apply to that count. With regard to him being an individual with an extensive criminal history, the Tennessee courts have ruled that Your Honor can consider not just his prior convictions, but the convictions for which he was found guilty that are before the court. So Mr. Johnson, by that count, has 3 aggravated assault convictions, a federal firearms conviction, a murder in the first degree conviction, a conspiracy to commit murder in the first degree conviction, and a second convicted felon in possession of a handgun conviction. 7 all serious, mostly all violent convictions. He's now 50 years old. Mr. Johnson's in his late 20s. So 7 serious, mostly violent convictions, and the state would ask Your Honor to find that is, in fact, a record of extensive criminal behavior should mandate consecutive sentencing in this case. We've also asked Your Honor to find that he's a dangerous offender. Well aware of, he's been convicted of murder first. It's pretty obvious he's a dangerous offender, but look beyond that to the circumstances of this case. This is a man who was not motivated by fear. He's not motivated by hate. This was a paid-for hit in the middle of the day at an open Memphis business, literally a cookie store, the assassination of an unarmed, innocent man. He was motivated simply by greed, desire for fame, and money. Your Honor also heard proof during the trial that, in fact, these two, Mr. Smith and Johnson, were on their way to commit some other crime against another PRE artist at some turkey giveaway when they happened upon the prize target, Dolph, and they acted like they did. We saw the video of all the shots. Just a stone cold execution that put many people in danger only for greed and the desire for fame. Is that a dangerous person? That's absolutely a dangerous person. The Wilkerson factors to consecutive sentencing relate to the severity of this offense, a paid-for hit in the middle of the day in Memphis, and are they necessary to protect the public from this man? A man who is motivated to commit this first-degree murder in broad daylight, putting others in danger just because of greed and desire for fame. We heard this was part of a larger scheme to kill other PRE artists as well. That is evidence Your Honor can take into account. We heard testimony of it at the trial. I think all that points to how dangerous this man and the absolute need for consecutive sentencing in this case. I think Your Honor is very well, within the court's discretion and the law to order each and every one of these sentences consecutive and to give him the maximum sentence on each and every count. I think Your Honor could give him 60 years consecutive to the life sentence and be well within the law and well within what should happen. At the very least, this is what the state is asking, at the very least, his convicted felon in possession of a handgun charge should be run consecutive at 20 years. I think Your Honor's within the law to give him every day you can for what we saw in that video. But at the very, very least, the state asks you to make the 20 years consecutive to his life sentence.
Thank you, Your Honor. On behalf of Mr. Johnson, we'd be asking the court to sentence him at the bottom of the range as to each of those counts with concurrent sentences. I don't disagree with the state that this court has broad discretion in sentencing in this case, but I think principles of sentencing have to be strictly adhered to. I'll talk first about some of the enhancement factors. Submit to the court on all of the enhancement factors, with the exception of whether he was a leader. I don't believe the proof in this case showed him to be either the leader or even a leader. Obviously, my client, as he stands before the court today, still persists in his innocence. As I speak regarding the record in this case and the facts in this case, I'm referencing the facts that were established at the trial that this court's relying upon. And what I would argue to the court there is what the facts showed in this case was that the individuals that were on the ground in front of that cookie store that day were not leaders in an offense. They were manipulated by others, whether it be Big Jook, Anthony Mims, whether it had been Hernandez Govan. That's what the proof showed, was individuals being manipulated by others who had power and were using that power and influence to get individuals to do their bidding. So I would object to the application of the enhancement factor that he is somehow a leader based on the proof presented at trial. As to the dangerous offender enhancement, I don't think that this instance allows for this court to meet the Wilkerson factors, because the added provision that the court has to consider is that the consecutive sentence is necessary, or the consecutive sentences are necessary in order to protect the public from further serious criminal conduct of the defendant. And I think it's easy for the state and even the court to look at this in a very technical aspect as it relates to the sentence in this case, but I think the sentencing principles require this court to redirect its attention to the practical effect. Mr. Johnson has been convicted of first-degree murder. That's life with a possibility of parole, which means he will not reach parole eligibility until he is served 51 calendar years. He will be in his mid to late 70s. And so the practical effect of the decision for this court is to render a sentence that is sufficient but not greater than necessary to effect the goals of sentencing by the least restrictive means available. And when you're looking at consecutive versus concurrent sentencing specifically, how is there an indication that a consecutive sentence is warranted based on the Wilkerson factors for someone who, by operation of law and a sentence already rendered by this court, won't even see a parole eligibility until he's in his mid to late 70s? There are multiple empirical studies that talk about recidivism rates and the drastic decrease in recidivism for offenders once they reach the age of 55 years old and older. He will be much older than that based on the sentence already rendered. And so there is no need, I would suggest to the court, for further protection of the community by rendering a consecutive sentence on either count. A life sentence has the practical effect, especially with Mr. Johnson, of being a life sentence. I know the court's also well aware of life expectancy tables of those incarcerated and the likelihood that someone will even live to their mid-70s after being incarcerated for 51 calendar years. The practical effect of that sentence is it's a life sentence, which is intended to be by the legislature. To come in today may make people feel better about how this sentence was rendered by stacking year upon year upon year, but it doesn't have the practical effect of of affecting any goal of sentencing. A life sentence promotes respect for the law. It's sufficient, which he has. A life sentence is a significant general deterrent to others that lets them know that being convicted of this conduct, engaging in this conduct, results in serious penalty. There is nothing to be gained in furtherance of the principles of sentencing, which this court is bound by stacking the sentence beyond that of the life sentence that's from the first-degree murder conviction. And we would ask this court to sentence Mr. Johnson, as I said, at the bottom of the sentencing ranges for the other two counts concurrently.
In determining the appropriate sentence for this offense, this court has to consider any evidence presented at trial and the sentencing hearing, the pre-sentence report, the principles of sentencing and arguments made as to sentencing alternatives, the nature and characteristics of the criminal conduct involved, the evidence and information offered by the parties on the mitigating and enhancement factors, any statistical information provided by the Administrative Office of the Courts as to sentencing practices similar as to sentencing practices for similar offenses in Tennessee, and any statement the defendant made, if any, on his own behalf about sentencing and the defendant's potential for rehabilitation or treatment. Before I continue, Mr. Evans, did you file any mitigating factors?
I did not.
This court conducted a trial back in September where we heard from witnesses to this murder, Mr. Adolph Thornton. Much like the state categorized, this was a crime of envy and greed, money and fame. And the proof showed us that. We heard from several witnesses. We heard from Mr. Thornton's sister. Testified she attended Mr. Dolph's funeral. We heard from Mr. Hawkins, who was a part of his security team, who had worked for him for several years, who traveled with him. He was in his presence quite often, and he talked about the victim in what he was trying to do, and that he was performing in concerts But he also talked about that there was some sort of beef between CMG and PRE. He didn't quite know what it was, but he testified that Mr. Thornton, Young Dolph, often called the artist out in his music. And at times that did translate into some violence. But he wasn't a part of it. But he was aware that that did exist. You watch the video of this crime. Mr. Hopkins identified Young Dolph's car because of some unique rap. And he identified Young Dolph and his brother Marcus in the car together. And talked about how this whole thing has affected his brother Marcus. Then we heard from Cornelius Smith, who is a co-defendant, who came into court, told you about his problems with pills, and told you about being part of a clan. Told you about a plan to kill, that there was a hit on several people of Young Dolph's organization. And he told you about he and the defendant, Mr. Johnson, taken out that morning in November of 2021 to find some of Young Dolph's folks who were possibly at a turkey drive down in Westwood. The video was played for Mr. Johnson, and he explained what was going on. He also explained the relationship between himself and another co-defendant who was called Quick. He said he was older, lived in Orange Mound, and he bought drugs from him. And he said that's how he met the defendant, Justin Johnson, because he was around Quick. They also called the defendant, Justin Johnson, straight draw. He said Quick was a negotiator, trying to get a deal with Big Jook. And he said Jook had a hit on Dolph's head. And then so Quick started negotiating $100,000. Mr. Smith testified that he and Mr. Johnson, the defendant, were going to do it together. And they were going to give Quick $10,000 apiece. And he said that this had actually been the plan for a few weeks. He said on this particular day, the defendant came and got him from his father's house. They knew that they were doing this turkey drive down in Westwood. That there were artists, that there were prices on the artists' heads by Jook. defendant showed up in a white Mercedes. He got in, there were guns in the car. It was a Draco and a handgun. He testified that the defendant had on gloves already. And then he handed Mr. Smith gloves. He said that they sitting at the light at Lamar and Airways, and lo and behold, Dolph comes down the street. Wow. They trailed Dolph down Airways, made the block, and came up the back way. They didn't see him get out of the car, but they pulled up behind Dolph's car at the cookie shop. Cornelius Smith testified that he was the first one out of the car. We saw in the video. We saw Mr. Smith get out of the car with the Draco. Mr. Smith started to shoot at Dolph. Then Justin Johnson got out of the car with a handgun. After they both fired, they got in the car. Justin drove. Mr. Smith testified he was hit in the leg and shoulder. And from that point, we watched on video where and how Mr. Smith and the defendant moved around from there. It's also important that witness testified, Mr. Smith testified that Justin Johnson FaceTimed Juke to let him know that they had completed that work. Juke said he would get up with them when he finished with his kids. Mr. Smith recalled that the defendant called his cousin in Whitehaven. They went and took the car that they were in to Quick, who put it at a house across the street from Quick's house, over in Orange Mound on Bradley Street. They changed cars. They went from the white Mercedes to a white truck, white SUV, Expedition. Then they went to the cousin's house in Whitehaven, where we saw on video they changed clothes. Saw a black Charger pull up. We saw the defendant Justin Johnson come out. Got a bag. Mr. Smith testified that this was a wound kit. That because he was injured. We saw the defendant get in the Charger for a minute. in the back seat. Mr. Smith testified that when they went back in the house, when Justin came back in the house with the wound kit, they patched each other up. And then he texted his girlfriend to come get him. We noticed in the video that Justin took a yellow hoodie out of the back of the car that pulled up at the apartment. And when he came back out, he had that yellow hoodie on. Mr. Smith testified that he wasn't really worried about getting caught. He wasn't beefing with anybody. He didn't even know Young Dolph. He just wanted the money. At the time, it was a lot of money. But once they split up, he kept trying to get in touch with the defendant for his money. At some point, Justin moved the car, the Mercedes, from the back of the house to the backyard in the bushes, in the house across the street from Kit. Mr. Smith testified that at some point he went back to clean the car up, to wipe it down. Mr. Smith testifies that Quet put he and Justin together, and Juke was the money man. Mr. Smith testified that he told the police he thought Justin had the same deal with Quet because Justin didn't bring him any money, didn't bring him his money. So at some point he thought maybe they did have a different deal. But he was under the assumption that they had the same deal. It's also important to note that Cornelius Smith testified that he was moving in conjunction with Justin Johnson, and as the proof was laid out in trial, we saw Justin Johnson in the same clothes from early that morning in the apartment where he lived in Crosstown, in the elevator going from the parking garage to the lobby of where he lived, in the elevator, and then waiting for the elevator in the same clothes. And then at some point we saw where he changed those clothes and kept that yellow jacket on after the murder. We also heard testimony from Dr. Juliet Scantleberry from the Regional Forensic Center, who performed the autopsy on Adolph Thornton, who testified that the cause and manner of death was homicide. (4035-102) requires that I consider the following sentencing principles. That every defendant shall be punished by the imposition of a sentence justly deserved in relation to the seriousness of the offense. to assure fair and consistent treatment of all defendants by eliminating unjustified disparity in sentencing and providing a fair sense of predictability of the criminal law and its sanctions. Punishment shall be imposed to prevent crime and promote respect for the law, providing an effective general deterrent to those likely to violate the criminal laws of this state, restraining defendants with a lengthy history of criminal conduct. To both the conspiracy to commit murder in the first degree and to the convicted felon in possession of a firearm, I find that the defendant is a range 2 multiple offender. State asked this court to find enhancement factor number 1, that the defendant had a previous criminal conviction for criminal behavior in addition to those necessary to establish the appropriate range. The pre-sentence report reflects that the defendant has five prior felonies, 3 of which are aggravated assault. Crime charged was second-degree murder, and they were all reduced to aggravated assault. That conviction offense was in 2017. There was also a weapons offense in federal court where he was convicted in February of 2019. There's also this attempt to commit a felony. And I'm not sure what classification that is. Do we have any idea, Mr. Hagan, Mr. Evans? Do we know what that is in the pre-sentence report? You want to commit it on October 18th of 2018?
We do not judge. It actually shows no sentence either, no sentence information either. So when I was doing
non-located, I don't.
Exactly. So when I was doing,
you just didn't include it.
My count, I counted that as a misdemeanor since we didn't know. It looks to be in association with the federal firearms count. So I think that for purposes of calculation and stuff, it only counts as one felony.
So I'm going to find that enhancement factor number 1, that the defendant has a previous history of criminal convictions or criminal behavior in addition to those necessary to establish the range. I'm going to add great weight to that in the fact that all of these sentences, all of these convictions appear to be violent offenses. So I'm going to find enhancement number 1. Enhancement number 2, the defendant was a leader in the commission of offense involving 2 or more criminal actors. We heard testimony from Mr. Cornelius Smith of this conspiracy, this plan to strike out that day to kill someone so they could get money. It was a hit. We heard testimony that it included Quet himself, Mr. Johnson, and Jook. We also saw that the defendant, we saw how he moved around. We saw videos. We saw videos where he moved in the middle of the night before this occurred to get that white Mercedes from a gas station. We saw where he exchanged vehicles. We saw where he made the phone call. Well, we heard testimony where he made the phone call to the cousin in Whitehaven so they'd have somewhere to go to hide out for a little while so they could patch up their wounds and change their clothes. Heard testimony that he actually went and picked up Cornelius Smith. So I'm going to find enhancement factor number 2 that he was a leader in the commission of offense involving 2 or more criminal actors. The state also asked me to find enhancement factor number 10, where the defendant had no hesitation about committing a crime when the risk to human life was high. The state is correct. This does not apply to the homicide of Mr. Adolph Thornton Jr. This applies to the other 2 charges, convictions. Into the act itself, where there were people in that store that cookie shop that day. There weren't a lot of people, thank goodness, but there was some employees in the business. There was a cashier whose life was in danger. The victim's brother was there. So certainly, the risk to human life was high. And I'm going to place great weight on that enhancement factor also. And although it appears that the defendant was on some sort of release after the aggravated assault convictions, because we don't have any proof of what kind of release. The pre-sentence report doesn't reflect it. I'm not going to find that enhancement factor mark number 13. Mitigating factors filed, none found. I'm going to find and sentence Mr. Johnson on the conspiracy to commit first-degree murder, 35 years. That's a range 2 offender. To the convicted felon in possession of a firearm, I'm going to sentence him to 15 years as a range 2 offender. State has asked this court to run these sentences consecutively. They've asked me to find that the defendant is an offender whose record of criminal activity is extensive. They've also asked me to find that he is a dangerous offender whose behavior indicates little or no regard for human life and no hesitation about committing a crime in which the risk to human life is high. The court also has to find that circumstances around this offense are aggravated. That confinement for an extended period of time is necessary to protect society from the defendant's unwillingness to lead a productive life and the defendant's resort to criminal activity in furtherance of an anti-societal lifestyle. And the aggregate length of the sentences reasonably relate to the offense of which the defendant stands convicted. state argues as to the defender having a record of criminal activity that is extensive, that the court can consider not just his prior history, which the court's already talked about, the 3 prior aggravated robberies, 3 prior aggravated assaults in the federal firearms case, but also this first-degree murder, conspiracy to commit first-degree murder, and convicted felon in possession of a handgun. It's unfortunate that we've witnessed Mr. Johnson's progression in violent activity. He's had these prior convictions which dealt with firearms, which dealt with violence and the lack of regard for human life. And it didn't get any better, it got worse. A whole lot worse. The state also argues as to the dangerous offender that the defendant was not motivated because of fear or hate. That this was greed and money and fame. This was just a hit, a way for him to further his career. The defense argues that practically that no other time above the life sentence that he's already been sentenced to will protect the community. The defense argues that the life sentence will make Mr. Johnson eligible for parole somewhere around 70 or in his mid-70s. And there's no need to protect the community any further because of that life sentence. I don't know that the court agrees with that. That sounds good. I don't know that the court agrees with that. These were crimes that were committed in our community in the middle of the day, in broad daylight, other people around, for greed. Greed, money, and fame. going to run count 1 and count 3 concurrently. For consent to the license. Lawyers,
We'll do the judgment sheets, Your Honor, get those to you in about 4 or 5 minutes.
thank you.
And Mr. Evans has filed the start of a motion for new trial. I think he has a request to get some transcripts, and I think we've emailed collectively about another date for the motion for new trial or status date, whichever Your Honor wants.
What about those other cases?
Just hold them.
Okay.
Have you spoken with the court reporter about how long that's going to take?
Not yet. I was hoping to do that today, and she's not here.
Right.
I have the order prepared to submit to Your Honor. I wasn't sure how long it would take her to do it, though. And so my suggestion with Mr. Hagerman was to let us wait and maybe set a status, wait until we can get with her and get an idea of...
So let's just set it. And on that day, if they're not prepared and they're not ready to go forward, we'll just reset it.
All right, thank you.
Okay? December 12th.
That date's agreeable, Judge.
I didn't give Mr. Johnson a total, did I? Life plus 35. Thank you. We set this matter to September 12th for a motion for new trial. Stand in recess.
Court stands in recess.
Mr. Hagerman. Did we renumber? We